This is Barry Zalma on insurance. I'm an attorney retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to speak about anti-insurance fraud programs that are practiced across the United States, because many states have enacted anti-fraud statutes and regulations that now require insurers to institute effective anti-fraud programs. Good business sense should have directed and dictated the existence of such anti-fraud programs from the date the first insurance policy was issued, but insurers have always been caught in the catch-22 obligation to deal with each insured with the utmost good faith. Insurers, not wishing to be accused of acts of bad faith, have always seemed to prefer to pay fraudulent claims rather than fight. That it was necessary for states to enact statutes compelling insurers to protect themselves has to be unique to the insurance industry, since no other industry is compelled by law to defeat fraud perpetrated against it. The essence of an anti-fraud program in the insurance industry is the commitment of the insurer to refuse to pay fraudulent claims. The details of an anti-fraud program are then tailored to the style of the particular insurer, its staff, claims personnel, executives, and counsel. The anti-fraud programs that have proved to be effective all center around the creation and operation of a special investigative unit, or SIU. The insurers who understand the need to fight fraud had SIUs in place long before any legislature or Department of Insurance considered it necessary to compel insurers to put one in place. An example of the way the anti-fraud programs have started working to assist insurers is seen in the case of Company X. Company X rents small storage spaces to the public. It found itself targeted for insurance fraud on a massive scale. None of the frauds were large. The insurance sold with the rental of the units was limited to $2,400, but the volume was becoming oppressive. Claims handlers would see the same person making an identical claim at 3 different storage facilities under 3 different names in a week. The storage facility insurers were losing money. They decided eventually to fight. Even if the fight cost more than the total possible claim, they concluded it was best overall to their business to fight back. The storage company's insurers established an anti-fraud program to staunch the bleeding of funds due to fraud. That program included intensive training of adjusters to recognize the red flags of fraud common to the storage industry, and the referral of every claim with a potential of fraud to counsel. The insurers instructed counsel to demand an examination under oath of the certificate holder or claimant, the renter of the storage room, and required every claimant to provide documents including a sworn proof of loss to prove his or her loss. Not surprisingly, 90% of the individuals from whom an examination under oath and proof of loss were demanded failed to appear. Their claims were denied for refusal to cooperate with the claims investigation. The insurers evaluated those who did appear and paid legitimate claims, but refused to pay claims they believed were fraudulent. Since the beginning of this aggressive stance towards fraud, Company X has seen its average total claim costs, including payment of adjusters, lawyers, administrative staff, and indemnity, reduced from $1,100 a claim to $850 a claim. Since the insurers receive 4,000 claims every year, the aggressive stance resulted in a clearly quantifiable savings of $1 million annually. This example can be extrapolated to massive savings if applied to bigger organizations. The community of fraud perpetrators is fairly large. They talk with each other. They know which businesses will not pay without investigating, and those that are easy touches. Once the word is out that it is difficult or impossible to gain money by fraud from one insurer or business, the fraud perpetrators go elsewhere. One problem with the fight against insurance fraud is that its success is hard to quantify. There's no way to say precisely how much a business is saved when a fraudulent claim is not paid, since the business or insurer owed nothing in the first place. Did the business save $80 when it did not pay a fraudulent claim for broken glasses? An adjuster might estimate that by stopping the single $80 fraud, the business has saved $80,000 in claims not made in the future. But executives want evidence. The people who operate insurance companies are, of course, interested in making a profit. They want to know what the fraud investigation saved, and if the amount saved exceeded the cost to save it. People involved in the fight against insurance fraud know that fraud perpetrators avoid insurers that make it difficult for them to collect a fraudulent claim. The Company X example above illustrates this vividly, and I lived it. I took dozens of examinations under oath and helped insurers of Company X to deny many more claims because of the failure of the claimants to appear for examination under oath or submit a proof of loss. They just went away, and it was very successful, even though it seemed to be more costly on the individual basis. The total cost was less. In every case, an SIU claim is responsible for some, if not all, of the difference. There is also a tendency for certified fraud examiners, SIUs, and private fraud investigators to be seen only as an expense to management. The fight against fraud improves the profits of a company in the long term, seldom in the short term. The fraud investigator should propose methods to avoid fraud, accounting controls to keep personnel from making payments to potential fraud perpetrators, and the initiation of a company policy that all claims of bodily injury or property damage, no matter how small, must be reported to the appropriate insurer and to the fraud division of the state insurance department. Setting up a policy of zero tolerance to fraud, no matter how small or how large, will improve the profits of an insurance company, the intended victim of a crime, after it has been in effect for a considerable period of time. SIUs and SIU investigators often have difficulty because local state prosecutors simply are not willing to pursue the crime of insurance fraud, even though in 47 states the insurance industry is required to pay money into a special fund, creating a fraud division with the state's Department of Insurance. The California Fraud Division, for example, states that its purpose is, quote, to protect the public from economic loss and distress by actively investigating and arresting those who commit insurance fraud and to reduce the overall incidence of insurance fraud through anti-fraud outreach to the public, private, and governmental sectors. This is a wonderful purpose, if only it worked. Most fraud divisions, like the California one, receive reports of suspected fraudulent claims as required by statute. And for example, the California Department will receive as many as 1,500 reports of suspected fraudulent claims every month. And it has statewide perhaps 50 investigators. They cannot physically, emotionally, or practically investigate all of the reported suspected fraudulent claims. Even when those claims are investigated and referred to a local prosecutor, the local prosecutors often fail to pursue the case because no one was hurt, no one was assaulted, no one was battered, no one was killed. Only an insurance company was faced with a lawsuit that would cost them money. I can state from personal experience that the California Department of Insurance, after completing an investigation of a case I presented to them from one of my clients, that included a sworn deposition testimony by an insured who admitted that his claim was fraudulent, and the sworn testimony of 5 independent witnesses who also established that a claim was fraudulent. And when nothing happened after it was referred to the Department of Insurance, there is a statute in California that requires the district attorney to advise the fraud division and the insurer of the reasons why it has not filed a criminal complaint. They didn't tell us. So I made a demand to the district attorney and eventually got a meeting with the prosecutors in their offices to ask them to explain why they had not filed a criminal complaint. And the answer was there was insufficient evidence to file a criminal complaint. I said, thank you. We denied the claim, which was not pursued, and closed our file. And the fraud division was found to be useless, as was the Los Angeles District Attorney's Office with regard to that particular fraud. Most insurance frauds go undetected. It is a very successful business, and no one really knows how big it is. But with a thorough investigation by an effective SIU and with the assistance of effective counsel, fraudulent claims can be defeated civilly, and rarely you might even find a district attorney willing to file a criminal complaint. This video was adapted from my book, Zelma on Insurance Claims, Part 110, Second Edition, which is available from Amazon.com as both a Kindle book and a paperback, and is part of the 10-volume set of Zalma on Insurance, details of which are available at my website, zalma.com, by clicking on the link to the Insurance Claims Library. If you found this video to be interesting or useful to you, please refer it to your colleagues. It's free. And please subscribe to my YouTube channel, my Rumble channel, and to my blog so that you can learn about future videos and future blog posts. Thank you for your attention.